Houston, our instruments are showing that we have a incoming message from deep space. Repeat, Houston, we have an incoming message from deep space. Houston, we'll begin playing message now. Houston, we're going to try and translate that up here. Hold for translation. Translation complete. We'll begin playing message now.
Hey, it's me, Melissa.
What do you do when the aliens invade? Take a shot of MK Ultra and watch Melissa Jade. Put on your tinfoil hat and tune right in. We got their crime spree, flat earth theories, government conspiracies, a complex Mandela effects, unidentified optics, a mind expanding, fake moon landing, what it all bends understanding. It's me, Melissa. It's me, Melissa. Aliens is on the sun or in Area 51. Time travels, unravels, haunted castles, cops are baffled, potential experimental thoughts that make you transcendental. It's me, Melissa. It's me, Melissa. Crime sprees, flat earth theories, government conspiracies, complex Mandela effects, unidentified objects, a mind expanding, fake moon landing, what it all bends understanding. It's me, Melissa. It's me, Melissa.
Hi, guys. Hey, Amber. Hey, Nace. Hi, Sarcastic. Harlot. Crime Sleuthin. Crime Sleuthin says, I could hear this from the other side of the house. Awesome. Hi, Lucia. Cool Gamer. Harlot. People Night. How are you guys? Happy Thursday. Hi, Tinker Tot. I know 87. Look at me go, right? All right. So, first off, did you guys see how Danny Masterson got life in prison? Like, put aside the Kohberger stuff for a second. Hi, Joseph. How are you? Hey, Wolfie. Did you guys see how Danny Masterson got life? Life. Which is like, wow. Hi, Derek. How are you? That's here. Let me show you guys. That's the guy from that 70s show, Amber. Masterson. That's the guy from that 70s show. And he got 30 years to life for the RAPE after emotional victim statements. So the former That 70s Show actor Danny Masterson was sentenced to 30 years to life in prison today after he was convicted of RAPEing two women. A Los Angeles jury found Masterson 47 guilty of 2 counts of forcible RAPE in May during a retrial of a case involving 3 women. Masterson will serve 2 15-year sentences consecutively, one for each charge. He must also register as a sex offender. The third count against Jade and Doe, number 3, was declared a mistrial and has since been dismissed after prosecutors said they would not retry Masterson on the RAPE charge. Masterson pleaded not guilty to 3 counts of felony RAPE, following accusations by 3 different women, including a former girlfriend. The alleged attacks took place between 2001 and 2003. So, yeah. I agree, Joseph, and it kind of reminds me of everything going on with the Backstreet Boys? What's his name? Except his is even worse because, hi Evie, his is regarding mentally challenged women. And what's his name? Nick Carter, right? Yeah, Harlot. Really, Marcus? Wow. Nope, they waste no time. So, yep, he's convicted. Bam. He's done. So that's, what's his name? I forgot what his name was on that 70s show. You don't know what's going on with Nick Carter, Amber? Oh my God. Sloan, Sloan, he does really good like videos on it. And he was straight up threatened for his video on exposing Nick Carter from Nick Carter's wife. Oh, it's I'll send you the links, Amber. But Nick Carter has a bunch of allegations against him. You guys didn't hear about the Nick Carter stuff with Nick Carter? Oh, it's bad. It's bad. Yeah. Go, if you type in Sloan, I'm sure you've heard of Sloan. Yeah, he was Hyde. Thank you, Harlot. Hi to Lila Shark. You haven't either, Nace? Type in Sloan and Nick Carter. And like I said, Sloan released and he was covering the Nick Carter stuff. And he was threatened. Like, he legitimately got threatened while covering it. I like Sloan too, Harlot. Here, I'll show you. 1 second. All right. You go. So Nick Carter was like exposed for having like all of these inappropriate relations with like underage girls, and then girls who are even struggling with mental disabilities. And then you could see Sloan did his initial exposing Nick Carter video, and then after that you could see Nick Carter and his wife are threatening me and my family. I'm scared for my life. I remember when he originally dropped this video and he showed that he was getting from Nick's wife, and he was scared for his life and he was contacting his lawyers and stuff. It was crazy. It was crazy. But this has been like, one of his victims has spoken out, and this has been in court. I don't know how far it's gone though. It's crazy. So yeah, that's what's going on with that. So yeah, you have Danny Masterson, 30 years to life. Stuff going on with Nick Carter. Definitely check it out. It's interesting. But I wanted to go over, even though they've kind of been out for a couple of days, the Kohberger documents and break them down and get your guys' feedback, discuss them, hear what you guys think about it. There's really the one big one. Which was the response to state's notice of intent not to cross-examine defense witnesses, direct court decision, and records to explain witness contact. And so Let's scroll through that, and then I have an interesting article for us to go over. All right. So it says, come now, Bryan Kohberger, and through his attorney, responds to the state's notice of intent not to cross-examine. And this is all regarding Vargas, guys. So it says, the court conducted a hearing on August 18th on Mr. Kohberger's third motion to compel. 4 witnesses testified for the defense, and the state reserved the right to cross-examine 2 witnesses. On August 30th, the state filed notice that it does not intend to reopen the hearing and cross-examine those 2 witnesses. Response. Mr. Kohberger's defense team has reviewed the exhibit and provides the following response. At first blush, it appears the issue before Judge Whitney in the case that was referenced was that the state was seeking a protective order relating to a database that produced information leading to Mr. Dalrymple's arrest. However, the decision Judge Whitney announced was on a different issue and was made without the benefit of expert testimony relating to the forensic and investigative genetic genealogy process. So everything keeps coming back down to this IGG. It is noteworthy that even without the benefit of that testimony, Judge Whitney concluded that the state needed to turn over in discovery everything in its possession relating to genetic genealogy, and the defense was welcome to bring further motion on the issue. This court is asked to decide something different. The information sought by Mr. Kohberger through his motion to compel is the same information that the state seeks to protect with its motion for protective order. The SNP profile created on behalf of the state and the genetic genealogy process directly used by the state to identify Mr. Kohberger. Mr. Kohberger is not asking for a genetic genealogy database, rather the analysis and documentation utilized to identify him. Mr. Kohberger has also asked for the SNP profile, and the state has agreed to provide it. So this is the big fight, and I'm really curious whether they're going to get approved for this or not, whether the judge has to make a ruling eventually. Hi, Rebecca. The judge has to make a ruling eventually. What it's going to be, I don't know. Hi, Tonka girl. So this court is left to decide whether to shield the analysis and documentation developed and used to identify Mr. Kohberger or to order it to be provided for his defense. This court makes its decision with the benefit of expert Steve Mercer explaining the duties of attorneys to examine this evidence and the types of legal decisions that can be made based on this evidence. This court has the benefit of knowing, based on expert testimony, how SNP results are produced using bioinformatics. Further, expert testimony described how genetic genealogy tracing is conducted and the documents generated by a genetic genealogist showing the analysis end result. Further, this court has the benefit of expert testimony describing how SNP testing can be compared against STR testing for contaminants and mixtures, as well as how the SNP and genealogical data can impact statistics. Lastly, this court has knowledge of the intricacies of prohibited law enforcement access to various DNA databases. The testimony the court received in the hearing relating to this loophole is not something Judge Whitney had the benefit knowing. It is important for the court to be aware that this same information has now been published on August 18th in The Intercept. This article details forensic genetic genealogy and the loopholes utilized to obtain information in contradiction of authorization. The Intercept is an online journal that has existed since 2014. Open Source Information states this is an award-winning news organization dedicated to exposing the powerful and holding them accountable. So this is again referencing that case and how it differs. This court received such documentation attached to the declaration of Ann C. Taylor in support of third motion to compel. In Mr. Kohberger's case, the Leda County prosecutor, the Moscow Police Department, the Idaho State Police, and the FBI worked together to investigate the case and identify a suspect. At some point, genetic genealogy was utilized for identification. That information remains withheld from Mr. Kohberger. Mr. Kohberger does not even know when this began or when he was supposedly identified. The memorandum contains a requirement that the Federal Department of Justice policies must be adhered to and that agencies must sign a memorandum of agreement to follow such policies. The DOJ has a policy regarding forensic genetic genealogical DNA analysis and searching. That policy requires that the prosecutor and investigating agency collaborate. That policy also requires that investigative agency only enter and search DNA databases that permit law enforcement to use their services. That policy requires that all forensic genetic genealogy profiles, account information, and data shall be retained by the investigative agency for potential use during prosecution and subsequent judicial proceedings. There is a relationship between local, state, and federal government to work together. DOJ policy requires retention of analysis and materials for use in judicial proceedings. This knowledge, in addition to the potential of misuse of information, is something that is discoverable and necessary to Mr. Kohberger. The duty of disclosure is an obligation of not just the individual prosecutor assigned to the case, but of all the government agents having a significant role in investigating and prosecution the offense. The FBI has been compelled to turn over its CAST report related to cellular data evidence and its investigation related to identification of the car. The investigation related to the car included hundreds of names of individuals owning a white Elantra. The evidence held regarding DNA is no different. The court in Dalrymple incorrectly permitted the state to hide material from the defense by claiming they did not have it. That is not how discovery works when the state decides to work with outside agencies to take liberty from someone. This court has thus far shown that the FBI does not exist outside the discovery rules. It should not grant them immunity now. Conclusion: the transcript provided from the Judge Whitney does little to instruct this court about what should be decided. This court has a different question. Mr. Kohberger requests materials and analysis, not a database. These materials are required by the DOJ to be retained for use in judicial proceedings. This court has the benefit of understanding the process and the materials that were created in the identification of Mr. Kohberger by the state and its agents. Mr. Kohberger respectfully requests the court order the state to disclose the materials. Mr. Kohberger is happy to comply with any limiting order the court deems appropriate. And then it's signed out like that. Hi, anybody who's just coming in. Hi, OCD Shaggy. Hi, Angel D. Hippie Chick. This is the fight of their life. Everything comes down to this IGG, guys. And so it's included in it is the article, police are getting DNA data from people who think they opted out. And it says forensic genetic genealogists skirted GED match privacy rules by searching users who explicitly opted out of sharing DNA with law enforcement. So again, this is not about whether or not it is Bryan's DNA. This is not what the fight is about. It's about whether or not they appropriately use these databases. Hi, Musicity Mom. It's about whether or not when they use the sites that the people knew that their DNA were going to be used to potentially identify a suspect in a crime. And their argument, hi, Snot Rocket, ear hustling. their argument is it's been used before. It's been done before. So show to us that it's not being done now. CC Moore. So it says genealogists like Moore hunt for relatives and build family trees just as traditional genealogists do, but with a twist. They work with law enforcement agencies and use commercial DNA databases to search for people who can help them identify unknown human remains or perpetrators who left DNA at a crime scene. The field exploded in 2018 after the arrest of Joseph James DeAngelo as the notorious Golden State Killer, responsible for more than a dozen murders across California. DNA evidence collected from a 1980 double murder was analyzed and uploaded to a commercial database to hit to a distant relative helped a genetic genealogist build an elaborate family tree that ultimately coalesced on DeAngelo. Since then, hundreds of cold cases have been solved using this technique. Moore, among the field's biggest evangelists, boasts of having personally helped close more than 200 cases. The practice is not without controversy. It involves combing through the genetic information of hundreds of thousands of innocent people in search of a perpetrator. And its practitioners operate without meaningful guardrails, save for interim guidance published by the Department of Justice in 2019. The last 5 years have been like the Wild West, Moore acknowledged, but she was proud to be among the founding members of the Investigative Genetic Genealogy Accreditation Board, which is developing professional standards for practitioners. With this incredibly powerful tool comes immense responsibility, she solemnly told the audience. The practice relies on public trust to convince people not only to upload their private genetic information to commercial databases, but also to allow police to rifle through that information. If you're doing something you wouldn't want blasted on the front page of the New York Times, Moore said, you should probably rethink what you're doing. If we lose public trust, we will lose this tool. Despite those words of caution, Moore is one of several high-profile genetic genealogists who exploited a loophole in a commercial database called GED Match, allowing them to search the DNA of individuals who explicitly opted out of sharing their genetic information with police. So again, exposing light on this. Hi, Claus. Sexy thing, Claus. So again, hi, B Crumbs. Mara is shedding light on this loophole because as awesome as this, hi, Pointer Lover, as awesome as this IGG is, right? It's amazing. It's incredible. It's solved so many cold cases. But being that it's so new, there's a lot of room for error. And there's not a lot of guardrails, as they put it. And there's loopholes. And corners can be cut. And they want to know that a corner wasn't cut here. It's not about whether or not it's Bryan's DNA. And I hope that people can focus on that. Anne can't argue that it's Bryan's DNA. It's Bryan's DNA. Hi, Vix. It's Bryan's DNA. What are you going to do when you can't fight that it is your client's DNA? You're going to fight how they got it. Now, I'm not going to say that it's not an important argument or a valid argument. It is. It is. But I think the fact that it's his DNA at all should speak volumes whether he is guilty of the crime. Yeah, Mara. Hi, Callie Dime. So it says the loophole, which a source demonstrated for the intercept, allows genealogists working with police to manipulate search fields within a DNA comparison tool to trick the system into showing opted out profiles. So people who said, nope, I don't want my profile to be used for police to search to find, like, you know, to match criminals and stuff, well, they still can use it. In records of communications reviewed by The Intercept, Moore and two other forensic genetic genealogists discussed the loophole and how to trigger it. In a separate communication, one of the genealogists described hiding the fact that her organization had made an identification using an opted-out profile. So this is Anne's entire freaking argument, is if it's happened before. Okay, Angel, I'll check. Thank you. If it's happened before, it's not his DNA. What do you mean, Twizzle Stick? Yes, it's a direct. So again, hippie chick, this is a tip. They cannot make an arrest off of this. It's just a lead. It's just a tip. That is why they had to do a direct DNA match, which they did. Hi, ATS News, which they did with the buccal swab, right? But that's not what Anne's fighting. The Anne's fighting is, how did you even get in the direction of my client? Prove to me that the protocol was followed versus a loophole like what was done here. Now, even if a loophole was taken, it doesn't mean that it's not Bryan's DNA. It's Bryan's DNA. It's a direct match. It's never going to be 100. What do you mean, Twizzle Stick? The communications are a disturbing example of how genetic genealogists and their law enforcement partners, in their zeal to close criminal cases, skirt privacy rules put in place by DNA database companies to protect their customers. How common these practices are remains unknown, in part because police and prosecutors have fought to keep details of genetic investigations from being turned over to criminal defendants. As commercial DNA databases grow and the use of forensic genetic genealogy as a crime-fighting tool expands, experts say the genetic privacy of millions of Americans is on jeopardy. Moore did not respond to The Intercept's request for comment. To Tiffany Roy, a DNA expert and lawyer, the fact that genetic genealogists have accessed private profiles while simultaneously preaching about ethics is troubling. If we can't trust these practitioners, we certainly cannot trust law enforcement, she said. These investigations have serious consequences. They involve people who have never been suspected of a crime. At the very least, law enforcement actors should have a warrant to conduct a genetic genealogy search, she said. Anything less is a serious violation of privacy. And I don't necessarily disagree with that. I think people are still confused with the genealogy is entirely separate than the DNA on the sheath matching the, yes. Correct, yeah. Well, we heard about that, Pointer Lover. It's never going to be, it's never going to be 100%. Yeah, Anne is only going to focus on exculpatory evidence. Prosecution's only going to focus on inculpatory evidence. That's just the way it goes. Right, Dave. And again, that doesn't, and I don't say that to minimize, hey, if a corner was cut and they went about things the wrong way, that's not cool either. But I don't think it makes Bryan any less guilty of the crime. But I do have, these are the concerns that I've been expressing from the beginning about a potential of a corner being cut. He could still be guilty and a corner or a loophole being taken, and that's not cool. It's never going to be 100% twizzle stick, though. It's always going to be like 99.9988 whatever percent it is. So the DNA entered in CODIS comes from individuals convicted of or arrested and is often referred to as junk DNA. Short pieces of unique genetic code that don't carry any individual health or trait information. It's not telling us how the person looks. It's not telling us about their heritage or their phenotypic traits, Roy said. It's a string of numbers like a telephone number. In contrast, the DNA testing offered by direct-to-consumer companies is as sensitive as it gets. It tells you about your origins, it tells you about your relatives and your parentage, and it tells you about your disease propensity. And it has serious reach. While CODIS searches the DNA of people already identified by the criminal justice system, the commercial databases have the potential to search through the DNA of everyone else. Individuals can upload their test results to any number of databases. At present, there are 5 main commercial portals. Ancestry and 23andMe are the biggest players in the field, with databases containing roughly 23 million and 14 million profiles. Individuals must test with the companies to gain access to their databases. Neither allow DNA results obtained from a different testing service. Both Ancestry and 23andMe forbid police and the genetic genealogists who work with them from accessing their data for crime-fighting purposes. We do not allow law enforcement to use Ancestry's service to investigate crimes or to identify human remains, absent a valid court order. Ancestry's privacy policy notes. The 2 companies provide regular transparency reports documenting law enforcement requests for user information. MyHeritage, home to some 7 million DNA profiles, similarly bars law enforcement searches, but it does allow individuals to upload DNA results obtained from other sources. And then there are Family Tree DNA and GED Match, which grant police access but give users the choice of opting in or out. Both allow anyone to upload their DNA results and have upward of 1.8 million profiles. But neither company routinely publicizes the number of customers who have opted in, said Leah Larkin, a veteran genetic genealogist and privacy advocate from California. She did testify. Larkin writes about issues in the field, including forensic genetic genealogy, which she does not practice, on her website. Larkin estimates that roughly 700,000 GED match profiles are opted in. She suspects that even more are opted in on Family Tree DNA. Opting in is the default for the company's U.S. customers, and it's not obvious how to opt out. But even opting out of law enforcement searches doesn't guarantee that a profile won't be accessed. A loophole in GED Match offers users working with law enforcement agencies a backdoor to accessing protected profiles. A source showed The Intercept how to exploit the loophole. It was not an obvious weakness or one that could be triggered mistakenly. Rather, it was a backdoor that required experience with the platform's various tools to open. Okay, hold on. I'm switching back and forth. The genetic genealogy portion is not presented to the jury. It's not something that needs to be explained to court because exactly. And that's why they're like, we don't have to hand over anything. We're not even using it. Oh, 87. Hi, Missy L. Legendary. The man, the myth, the legend. I just wish the judge would make a ruling on this already. Okay. So again, they're continuing to talk about the loophole. This talks about how to opt out when you have a profile. So in 2020, she described the DNA project was using an opted out profile to make an identification and devising a way to keep that quiet. So why that's important is because you are using a profile that was opted out, meaning, nope, I do not want my profile used to identify any criminals, any perpetrator, any human remains. So legally, you're not supposed to do that. And they still used it. So if they used it in other cases, you need to prove to us, hi, Michelle, you need to prove to us that you didn't use it in the case of Bryan Kohberger. That is, again, the entire freaking argument. Not the argument that it's not Bryan's DNA. It is Bryan's DNA. But show to us that you did not do these loopholes to point in Bryan's direction. In July 2020, GED Match was hacked, which resulted in all 1.45 million profiles then contained in the database to be briefly opted in to law enforcement matching. At the time, BuzzFeed News reported just 280,000 profiles had opted in. GED Match was taken offline until such time that we can be absolutely sure that user data is protected against potential attacks. In January 2021, GED Match changed its terms of service to opt everyone in for searches involving unidentified human remains, making the backdoor irrelevant for genealogists who only worked on Jane Doe cases, but not those working with authorities to identify perpetrators of violent crimes. So exploitation of the GED Match loophole isn't the only example of genetic genealogists and their law enforcement partners playing fast and loose with the rules. Law enforcement officers have used genetic genealogy to solve crimes that aren't eligible for genetic investigation per company terms of service and Justice Department guidelines, which say the practice should be reserved for violent crimes like RAPE and murder only when all other reasonable avenues of investigation have failed. In May, CNN reported on a U.S. Marshal who used genetic genealogy to solve a decades-old prison break in Nebraska. There is no prison break exception to the eligibility rules, Larkin noted in a post on her website. This case should never have been used forensic genetic genealogy in the first place. So the FBI and the Riverside County Regional Cold Case Homicide Team had identified the victim of a 1996 homicide using the MyHeritage database, an explicit violation of the company's terms of service, which make clear that using the database for law enforcement purposes is strictly prohibited, absent a court order. So again, they're doing, The case presents an example of noble cause bias in which the investigators seem to feel that their objective is so worthy that they could break the rules in place to protect others. MyHeritage did not respond to requests for comment. Violations have even come from inside the DNA testing companies. So, GED Match co-founder unilaterally made an exception to the terms of service without notifying the site's users to allow police to search for someone suspected of assault in Utah. It was a tough call, Rogers told BuzzFeed News, but the case in question was as close to a homicide as you can get. It appears that violations have also spread to Ancestry, which prohibits the use of its DNA data for law enforcement purposes unless the company is legally compelled to provide access. Genetic genealogists told The Intercept that they are aware of examples in which genealogists working with police have provided Ancestry DNA testing kits to the possible relatives of suspects, what's known as target testing, or asked customers for access to pre-existing accounts as a way to unlock the off-limits data. So, as it turns out, the genetic genealogy work in the Golden State Killer case was also questionable. The break that led to D'Angelo came after genealogist Barbara Ray Venter uploaded DNA from the double murder to MyHeritage. Ray Venter told the Times that she didn't notify the company about what she was doing, but that her actions were approved by Steve Kramer, the FBI Los Angeles Division Counsel at the time. In his opinion, law enforcement is entitled to go where the public goes, Reventer told the paper. Oh, shit. Yeah, I could see. See, this is the problem. Okay, so that's exactly what's happening in Idaho, where Bryan Kohberger is awaiting trial for the 2022 murder of 4 university students. 4 months, the state failed to disclose that it had used forensic genetic genealogy to identify Kohberger as a suspect. A probable cause statement methodically laying out the evidence that led cops to his door conspicuously omitted any mention of genetic genealogy. Kohberger's defense team has asked to see documents related to the genealogy work as it prepares for an October trial, but the state has refused, saying the defense has no right to any information about the genetic genealogy in use to crack the case. Prosecutors said it was the FBI that did the genetic genealogy work, and few records were created in the process, leaving little to turn over. But the state also argued that it couldn't turn over information because the family tree the FBI created was extensive. Thank you, Lucia, for being a member for 4 months, including the names and personal information of hundreds of innocent relatives. They did say that. And the privacy of those individuals needed to be maintained. According to the state, it shouldn't even have to say which genetic database or databases it used. Kohberger's attorneys argue that the state's position is preposterous and keeps them from ensuring that the work undertaken to find Kohberger was above board. It would appear that the state is acknowledging that the companies are providing personal information to the state and that those companies and the government would suffer if the public were to realize it, one of the Kohberger's attorneys wrote. The statement by the government implies that the databases searched may be ones that law enforcement is specifically barred from, which explains why they do not want to disclose their methods. A hearing on this is scheduled for August 18th. Oh my. Preposterous. So, to date, efforts to rein in the practice as a violation of the Fourth Amendment have presented some problems. A person whose arrest was built on a foundation of genetic genealogy, for example, might have been harmed by the genealogical fishing expedition, but lacks standing to bring a case In the strictest, why can't I speak? Oh my goodness. In the strictest sense, oh my goodness, we're just going to go with it. It wasn't their DNA that was searched. In contrast, a third cousin whose DNA was used to identify a suspect could have standing to bring a suit, but they might be hard-pressed to prove they were harmed by the search. Thanks, Michelle, for being a member for 19 months. If police are getting hits to suspects by violating companies' terms of service, using databases that bar police searching, thank you, Dara, for being a member for 1 month. That raises some serious Fourth Amendment questions because no expectation of privacy has been waived. Of course, ferreting out such violations would require that the information be disclosed in court, which isn't happening. Just kind of scrolling through because it's all kind of very repetitive. So it says, Moore advocated for involving forensic genetic genealogy earlier in the investigative process. Doing so, she argued, could focus police on guilty parties more quickly and save innocent people from needless law enforcement scrutiny. In fact, she told the audience, she believes that forensic genetic genealogy could help to eradicate crime. We can stop criminals in their tracks, she said. I really believe we can stop serial killers from existing and stop serial rapists from existing. We are an army. We can do this, so repeat after me. Before leading the audience in a chant, no more serial killers. Okay, that's weird. So this is the rest of the article. And then this is the Idaho State Police. It was weird, right, Mara? Hey, me feet. All right, so this says the Idaho State Forensic Services Laboratory is extremely excited to announce that we have secured a Bureau of Justice Assistance grant to fund genetic genealogy testing and searching of unsolved Idaho cases. The cases we are starting with are unsolved homicide, sexual assault, and missing person and unidentified remains. Idaho is the first state in the country to take the statewide approach for this technology. Instead of each law enforcement agency having to negotiate their own contract pricing and quality control with a private lab and genealogist, ISPFS has done that at the state level through the Idaho. Okay. So this is the forensic genetic genealogy, DNA analysis and searching, the purpose and scope. Hey, this is what I went over that day. Remember last week? I think this is what I went over. So forensic genealogy is law enforcement's use of DNA analysis combined with traditional genealogy research to generate investigative leads for unsolved violent crimes. Forensic genealogy. Okay. So department laboratories currently do not analyze SNPs during forensic DNA casework. Thus, in appropriate cases, it is necessary to outsource biological material to vendor laboratories that perform FGG. A suspect shall not be arrested based solely on a genetic association generated by a GG service. If a suspect is identified after a genetic association has occurred, STR DNA typing must be performed, and the suspect's STR DNA profile must be directly compared to the forensic profile previously uploaded to CODIS. This comparison is necessary to confirm that the forensic sample could have originated from the suspect, which was done. If you guys remember, I went through this whole thing last week. And they took his buccal swab and they directly compared it. And if you, okay, so, and this part right here. So if a suspect is arrested and charged with a criminal offense while the FGG is in progress, the investigative agency shall promptly contact the relevant vendor, laboratory, or DTC service and direct that all testing cease at a point in time when the forensic or reference sample can be preserved. The investigative agency shall also request that the sample, extract, and amplicon be returned directly to the submitting law enforcement agency or custodial CODIS laboratory as applicable. If a suspect is arrested and charged with a criminal offense after an FGG profile has been entered into one or more DTC services, the investigative agency shall make a prompt formal request that all FGG profiles and associated account information and data held by any such service be removed from its record and provided directly to the investigative agency. The investigative agency shall document its request in compliance by the DTC service. All FGG profiles, account information, and data shall be retained by the investigative agency for potential use during prosecution and subsequent judicial proceedings. If a suspect is arrested and charged with a criminal offense after an FGG profile has been entered into an open data personnel genomics DNA database, the investigative agency shall promptly remove the FGG profile and all associated account information and data from the database. The investigative agency shall document the removal of this information and data. It shall be retained by the investigative agency for potential use during prosecution and subsequent judicial proceedings. So we read all that. Okay. So I have this article, and it says, Bryan Kohberger, expert witness in Idaho college murders, is allegedly reneging testimony. FBI investigates her claims. And this is about Vargas, guys. And it says, an Idaho prosecutor alerted the FBI concerning a genetic genealogy expert who testified during Bryan Kohberger's August 18th hearing after contradictory testimony. Days after genetic genealogy expert Daniel Vargas testified during the hearing, the FBI tracked her down to question her, according to what Kohberger's lawyers said. Hi, Esther. Last night, she was visited by 2 FBI agents and interrogated about her testimony and the findings of what her declaration. Kohberger's lead defense attorney, Ann Taylor, told the court. That, in our view, impacts Mr. Kohberger's due process rights. Lada County Prosecutor Bill Thompson explained that investigators had heard that Vargas was reneging on some of the things she was testifying to in court, prompting an investigation. Hey. When we heard that, I reached out to investigators and asked, "Can you figure out what's going on?" Thompson said. The FBI indeed undertook an investigation, and other reports are that Ms. Vargas claimed that some of what was in her declaration she had inadvertently agreed to or signed without fully reading it. Huh. And here's her declaration. So her declaration was, I, Gabriella Vargas. Yeah, wait, her name isn't Dan, it's Gabriella. So what the hell is that about? Gabriella Vargas. I'm an adult over the age of 18, and I have personal knowledge of the facts. I have been engaged as an expert in the above entitled matter since August 2023. My educational background is in administration of justice and criminology. I have spent my professional career working for the California court system, law firms, insurance, and finance firms. I got my start in this field after receiving unexpected DNA results in the spring of 2018. I am an investigative genetic genealogist specializing in Hispanic and African American ancestry, degraded DNA, and endogamy. I founded DNA ID, and I have run the business since the spring of 2020. Prior to my own company, I've spent several years doing IGG for other companies such as the DNADO Project and Identifinders International. 5, while working for those companies, I held the role of team leader, senior forensic genealogist, teacher, mentor, case auditor, intake specialist, and lab liaison. 6, I have taught IGG fundamentals, best research practices, and procedures. Blah, blah, blah. 7, I have contracted with the University of New Haven to provide a structured practicum for students, collaborated on cases. 8, through extensive and skilled genealogical research and analysis, I have successfully provided law enforcement with over 50 crime-solving investigative leads. 9, I work with law enforcement nationwide in an effort to identify previously unknown DNA contributors through a process known as investigative genetic. Investigative genetic genealogy, IGG. This technique has revolutionized cold case investigations and transformed the way violent crime suspects and skeletal remains are identified. 10, the sole focus of the traditional law enforcement databases like CODIS is to compare crime scene DNA against the genetic profiles for those who are known offenders with prior convictions. This process only utilizes 20 genetic markers and therefore limits the power of DNA analysis, which can and does lead to cases going cold. Investigative genetic genealogy combines advanced DNA testing with traditional genealogy research in an effort to identify a previously unknown DNA contributor in a family tree. 11, the DO recommends seek out investigative I'm trying to pick out and find what she would recant. Is widely known within my industry that many agencies use this technique as the first and only method. Maybe that part. The DOJ recommends that law enforcement seek out investigative genetic genealogy services only after all other investigative methods have been exhausted. It is widely known within my industry that many agencies use this technique as their first and only method. 12, the IGG process starts when law enforcement agencies reach out to genealogists seeking collaboration on a case and then contract with the individual for services. 13, chain of custody is best maintained when the requesting agency sends the crime scene DNA sample to a private lab that is capable of genotyping or whole genome sequencing. Once the sample arrives, the lab creates a genetic profile. The file is then uploaded. A list of matches who are biologically related to the subject is displayed. Okay. The databases tools. These database tools have known loopholes that allow a genealogist to see matches that have explicitly declined to participate in law enforcement matching. This is not a glitch in the programming causing this by accident. It is a standard feature within the tools that essentially tricks the system into displaying all matches as opposed to only those who have consented to law enforcement matching. This is not a loophole, nor is it something you will stumble upon. Using the tool this way requires effort and knowledge. That could be it. Number 15, databases for law enforcement cases require a fee be paid in order to upload the genetic profile. This is not the same for consumers who are not charged. Many in the field have been known to upload to these sites as a regular consumer to avoid paying the associated fees and to bypass having opted out of matches. In addition, some databases restrict law enforcement uploading cases. However, that has not prevented it from happening. 16, I am aware that law enforcement has obtained results in ways prohibited by the terms of service and prohibited by their own policies. So I'm curious which part she would have recanted. So it says, as Crime Online previously reported, Kohberger, was arrested. So is that it? Okay, that was it. I don't know, guys. Not recant, sorry, use of wrong word. Whatever was the word that they were just using, but I couldn't even pronounce it to be fair. They were using the word reneging. I couldn't, so I just said recant. Reneging? I don't know what that is. Reneging. So she was reneging on some of the things she was testifying in court. Reneging. I don't know what it means. So I used recant. So I'm sorry if it's the wrong word. And that Ms. Vargas claimed that some of what was in her declaration she had inadvertently agreed to or signed without fully reading it. I mean, she took back. So is that not the same thing? Okay. Reneging. Thank you. Taking back, recant, like you said. All right, so then you guys are just giving me shit. It's basically the same thing. Okay. Reneging. I don't know. I've never seen that word. And then like it also being like in the direct like little quote things too, it kind of bugs me out more. Reneging. Go back on a promise, undertaking, or contract. They have reneged on their promise to us. Thank you. Thank you. Oh, geez. I like saying it like reggaeton, renegade. It means you made a deal that you could come through on. Got it. Neither have I, Amber, and we're kind of from the same area too, so that would make sense. I've never heard the word. I'm sleeping. I don't want to try. Has it been confirmed that she? Nika, like, has it been confirmed that she renegade? Wait, crap. Oh crap! No, I forgot. I am from New York. We don't use that here. Crap! I have to scroll up to figure out how to say it again. Hold on. Renegade. Oh man. I don't know. I don't know, man. Can we just use a different word? Because I'm just gonna keep getting hung up on it. I feel like I'm just gonna like. I just don't feel comfortable. Yeah. Retracted, thank you. Can we just go with retracted, please? Hush up 87. Okay, I've never heard it before. Not comfortable. Yeah, she revoked it. She took it back. I think it's like abandoning a thought or going back on something. Well, I'm just going to say all of that instead of that word. Instead, renege, like magging, reneging. Oh, I could do that. Reneging. Yeah. Rhymes with, okay, I could do that. Thanks, OCD Shaggy. Dude, I'm telling you, it's more painful for me than it is for you guys. Well, I did say recant, and then everyone got upset, and then I didn't know if it was synonymous with recant. Jeez. But I'll forget in a minute how to pronounce it, so just please, let me just stick with recant. Okay. I would just love to know when the judge is going to finally make a decision on this. Thank you, Betty Joe. Stop it, Michelle. I don't even know, Angel. I don't even know. And then there's this one. Maybe this one has a better word than this. Because this one says FBI investigates key witness for Bryan Kohberger's defense. And it says prosecutors notice an alleged irregularity with some testimony from DNA expert Gabriela Vargas. And I don't play spades, but I'd love to learn it. I like card games. So it says, rather than cross-examine an expert witness for the defense of Idaho murder suspect Bryan Kohberger, Leda County prosecutor Bill Thompson flagged the FBI to investigate her following some contradictory testimony. Kohberger's defense has alleged grand jury irregularities, prosecutorial misconduct, and has attempted to discredit DNA methods used in the case. Gabriela Vargas, an expert on genetic genealogy, testified on the DNA issue during a hearing on August 18th. Days later, the feds knocked on her door, according to Kohberger's attorneys. And this is Gabriela. Last night, she was visited by 2 FBI agents and interrogated about her testimony and the findings on her I can't speak. And the findings of her declaration. Ann Taylor, Kohberger's lead defense attorney, said during an August hearing that, in our view, impacts Mr. Kohberger's due process rights. Thompson filed an explanation for the FBI interaction under seal last week, but more details have emerged in court proceedings. Oh, here we go again. Bryan Kohberger, prosecutor, says expert witness for defense reneging on testimony. There we go. Did I get it? Did I get it? Did I get it right? Like a leg? Reneging.
Hi, we're Visible, the
Hi.
wireless company with nothing to hide. Get
No?
unlimited 5G data powered by Verizon for $25 a month every month.
Just fuck it. Whatever.
Any objection to hearing the motion along with these two more motions to be heard on September 1, Wisconsin?
I don't believe so, Your Honor, having not seen exactly what the motions are, but if you're saying they're fairly straightforward, I would think that we could do that. If we look at the motions, we have an issue with great Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation with Vargas, give court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in
Yeah, you
electronic communications with others. Those indicated as it was reported to investigators.
I renege the clip. I take it back.
Heard of that, I reached out.
Pointless.
Said, please find out what's going on. The FBI agreed.
I'm reneging the clip, okay? So Thompson said, sorry. It was just the clip. I swear it wasn't my end. So Thompson said that through some of her colleagues, investigators heard that she was reneging on some of the things she was testifying to in court. All right, there's that word again. Yo, fuck, I hate that word. I hate that word. So again, here is Gabriel Vargas' written declaration, which we just went through. And it says, when we heard of that, I reached out to investigators and asked, can you find out what is going on? Thompson said. The FBI indeed undertook an investigation, and other reports are that Ms. Vargas claimed that some of what was in her declaration she had inadvertently agreed to or signed without fully reading it. The expert testimony had other controversy, with prosecutors asking the court for permission to delay cross-examination to a later date over a snafu with PowerPoint slides. Did I say that word right? That's another word I do not know. Snafu? It sounds like a Lion King character. What in the world? Oh, dear Lord. Doesn't snafu sound like it belongs to be like a little bird in the Lion King? An obnoxious bird next to Jafar. Either way. Over a snafu with PowerPoint slides. The exchange happened during an August 23rd hearing, but resurfaced last week after Thompson declined to cross-examine Vargas and another DNA expert, and former FBI agent Tracy Walder told Law and Crime that such an interview is atypical. SNAFU is an acronym that is widely used to stand for the sarcastic expression situation normal. All fucked up. What? What? Then snafu, like, it describes my life. What? Seriously? Used to describe the sarcastical expression situation normal, all fucked up. What? Do I know FUBAR? No, I know what a FUPA is, though. And I know the song that goes with it. But I don't know what a... No. What's a FUBAR? Dude, I don't know if I'm just like really tired tonight or what. FUBAR is fucked up beyond all repair. Oh, that's just me. Oh, that's my head. Man, my head's FUBAR. Got it. Nope, I've never heard of these acronyms. Where do you guys get them? Is there like a fucking site or something you get these acronyms from? I've never heard of them. Oh, so you all know them. Okay. All right. So I'm just out of the fucking acronym club, I see. I'm the only one who doesn't know what FUBAR is. Shit. It must be a New York thing. I don't know. I know what a FUPA is. That is it. That is it. I am not part of the FUBAR acronym shit. Oh, man. Shit. Oh, my. Oh, man. FUBAR and SNAFU come out of the military. Well, since when do they use something like SNAFU on a friggin' article? RBF, according to all my friends. I don't know what RBF is. I forgot what FUBAR meant already. I don't retain information well, if you guys have not picked up by now. New trivia game, guess this acronym. I fail. Oh yeah, fucked up beyond recognition. Yeah. That's what it is. I forgot what the other one is. Something about a normal situation. Something about the slides. I don't remember though. Oh, Jesus. Shit. What was the other one though? What was the Lion King one? SNAFU. Yes, SNAFU. SNAFU then. It was the situation normal. Situation normal. All fucked up though. Situation normal. All fucked up. Yeah, I got it. Yeah, it's my life. These acronyms really accurately describe my life, man. I'm feeling really attacked by these acronyms. Shit. Oh, man. What's hide that gravel? Is that HTG? HTG. Hide that gravel. I don't know what that means, but okay. SNAFU is not an acronym? SNAFU is just an adjective to describe a total. Oh my God. So I'm a SNAFU, Esther. I'm the SNAFU. Oh my God. Jesus. Fuck. This is embarrassing. I've never heard of this before. I was wondering why a freaking article would have an acronym on it. It made no sense. Oh, man. Okay. Well, we're just gonna roll with it. We're gonna see what else comes from the article. So The exchange happened during an August 23rd hearing, but resurfaced last week after Thompson declined to cross-examine Vargas, and another DNA expert and former FBI agent, Tracy Walder, told Law and Crime that such an interview is atypical. The FBI declined to comment, but legal experts told Fox News Digital that circling back for an interview with a witness who may have signed something she didn't read is a permissible move. I don't think it's entirely unusual for prosecutors to direct their investigators and agents of law enforcement to follow up with a witness, said Edwina L. Cox, a Boise-based defense attorney who is not connected to the case. That is a name if I've ever heard one. Edwina L. Cox. Unless something untoward happened, mere contact and follow-up is certainly not out of bounds. Kohberger was pursuing a PhD in criminology at Washington State University when 4 students at the neighboring University of Idaho were stabbed to death at 4 a.m. home invasion attack. Okay, so that's all repetitive. See, what I want to know snafu is if, well, opinionated, we just went through her declaration, and there was the only thing I could see that would be in her declaration that she would recant to. This is just her personal information, right? Her history, her experience. I can't see her recanting on that. This is her working with law enforcement. I can't see her recanting on that. Right here, number 11, possibly. The DOJ recommends that law enforcement seek out investigative genetic genealogy services only after all other investigative methods have been exhausted. It is widely known within my industry that many agencies use this technique as the first and only method. Maybe that. Number 13, it's just the process. I can't see. Number 14, possibly, where it says these database tools have known loopholes that allow a genealogist to see matches that have explicitly declined to participate in law enforcement matching. This is not a glitch in the programming causing this by accident. It is a standard feature within the tools that essentially tricks the system into displaying all matches as opposed to only those who have consented to law enforcement matching. This is not a loophole, nor is it something you will stumble upon. Using the tool this way requires effort and knowledge. That is possible. Or number 15. Databases for law enforcement cases require a fee be paid in order to upload the genetic profile. This is not the same for consumers who are not charged. Many in the field have been known to upload to these sites as a regular consumer to avoid paying the associated fees and to bypass having opted out matches. In addition, some databases restrict law enforcement uploading cases. However, that has not prevented it from happening. Or 16, I am aware that law enforcement has obtained results in ways prohibited by the terms of use and prohibited by their own policies. Those are the only 4 that I think would even be possible for her to renegade on. Was that, I don't remember what the word was, but I think. Yeah, well, she said that, yeah, that they have in the past, Belmoon, yeah. Renege, yes, thank you, not renegade. Oh my God. really struggle with this type of stuff. Well, and that's what I thought too, opinionated, where it's specifically said it's not a loophole versus no, it is a loophole, because the previous articles that we read said it is a loophole. But that's a great question, Mara. Mara says, anyone understand why the defense is pushing this instead of innocence? Because you can't, in my opinion. When you can't argue that he's innocent, when you can't argue that it is a match, what are you going to argue, right? It's her job to create reasonable doubt. It's her job to do this exact type of stuff. This is what you're going to argue, technicalities. Even though, listen, this is a good argument. Loopholes and things like this should not be done if this is what happened. But she can't focus on the fact that it's a direct match, so she needs to focus on something else. I heard someone speculate, and it made a lot of sense. Maybe the reason the unidentified DNA weren't IgG'd, making it a verb, because DOJ had more restrictions on the IgG. Right, ATS, just attack the process. Well, and just a lot of people think that there automatically has to mean that there's something more because of the things that Anne states in her motions. No, not necessarily. That it doesn't mean that there's not possibly something more, but it's not guaranteed that there is something more, because you have to remember, even if Bryan is guilty, Anne is going to fight for him all the same. It's her job. And when I've said that before, people are like, you expect Anne to be caught lying, to risk everything for Bryan? No, what do you mean? That is her job. He is entitled to a trial, whether he's innocent, like he's entitled to it. If he, you know what I mean? Like, and so she knows whether he's guilty or not. Even like, usually defense attorneys do not ask their client whether they're guilty or not. For their own peace of mind, they do not ask. But she'll know from the evidence. She has access to it. But she's going to fight for him all the same. And she knows what she can fight, and she knows what she can't fight. And there's so much she cannot fight. So she's going to focus on what she can fight. But ask yourself this: if there really was so much sketchy things going on, right? If there was so much sketchy things going on, there was so much snafu going on, why would Anne want to get those cameras out of the courtroom? If there was really something sketchy happening and prosecution was really covering shit up and you were in the process of exposing it, I would want to make sure that there was cameras recording everything. Ask yourself why Anne wants cameras out of that courtroom. And also, Anne got caught lying. They got caught lying about the fly. Anne knew that those photos were manipulated and zoomed up to his crotch after. That was not them streaming the feed in the courtroom. That was what people did with the feed after. If Anne was willing to lie once, what makes you think Anne's not willing to lie again? And I'm not coming at her for lying, but for all the people who thinks that, oh, well, Anne's not willing to lie. Yes, she is. Yes, she fucking is. She's willing to do things that are going to benefit her client the same way anyone is. It's what her job is. Right, Dara. It's just she's just doing her job. But she knew that wasn't anyone in the actual courtroom, any of the media who was zooming up on Bryan's privates. That was not the media. She knew that, but she still took the zoomed up edited version and made it seem like that. So all those people who are screaming about Bryan being innocent and like this, well, you're not going to acknowledge that Anne lied, right? I'm not like stomping my feet about it, but like, where are you about that? If you're going to acknowledge, you got to acknowledge it on all sides then. It was way exaggerated, Dara. And it was after. It was not the actual feed. It was not them in the courtroom zooming up on Bryan's crotch. It was some it was some random on Twitter, Jen. But I would want the cameras to be right up front and center if there was sketchy shit happening. No, she said that the media did it, Twizzle Stick, but it wasn't the media. It was Twitter, some random person on Twitter who did it. No, that was a lie, Dave Bays, because that was her argument that she used to get media out of the courtroom. And the media isn't who did that. Like, the media streaming in the courtroom isn't who did that. Okay, well, to be fair though, Violetta, right? And I listen, I don't like it either that, like, well, hey, why was this witness approached privately outside the courtroom? Like, I don't know the answers to that, but it's the FBI, so I don't know how the FBI does it. I don't know if maybe it was even a different case. Like, Vargas covers many different cases. Probably not. It probably is regarding this specific case, but with the FBI, they handle things completely different. But what's it called? There's nothing that says that they can't. So technically they didn't do anything wrong. But I have to believe that they have that documented. I don't believe that they wouldn't have it documented. That's correct, Belmoon. Correct. That is correct, Marianne. Yes. Me neither. Well, I heard about it, Angel, but I didn't see it. Nobody cares about Bryan's Twizzle Stick. She claimed it was the cameras She claimed it was the cameras in the courtroom that were zooming in on his fly in order to get them kicked out. She knew that was a zoomed in screenshot, so she lied to make her case sound better. Exactly. That is the problem. That right there. That in her motion, she included screenshots that were edited after the fact, did not come from inside the courtroom. Well, she is the one who claims. Well, yes and no, Mara. It's if there is exculpatory evidence, it's the prosecution's job to provide that to defense. It's the prosecution's job to provide everything to defense. But it's the defense's job, right, to focus on that and to bring that to light. But if there is no exculpatory evidence, like the state isn't going to be the one bringing the attention to it. That's going to be the defense. But they didn't need a cross-examiner, Violet, because the issue didn't come till after. That's the whole thing. So she didn't what was it again? Reneged her. She did not retract her part of her testimony till after. So yes, as far as the opportunity to cross-examine, no, they didn't want to cross-examine her. They had nothing to say then and there. But it was only after, in that forthcoming days, that she said that basically that she had signed to her sworn statement without fully reading it. The person called over, told them, and they called up, Bill Thompson called up the FBI and said, hey, can you look into it? So no, it has nothing to do with the cross-examining because the issue wasn't presented until after that. You know what I mean? Yeah, I'm going to just say recant. But I like I said, Violetta, I wish it wasn't done at the home either, like outside of court hours, and I wish it wasn't done like that either, because it's like, oh, this doesn't help. It just fuels the conspiracy aspect of it, but it's also the FBI, and so I genuinely do not know what the procedures are with the FBI and what they would do, what's normal, what's not normal. But I would absolutely think that they'd have it recorded. Well, and I don't think he was gonna cross-examine her anyway, because again, to Bill Thompson, he said, this is not something that I'm even going to entertain because we're not using the IGG. I have nothing to cross-examine her on because we're not using it. The IGG was a tip. It was a tip. Violetta. Yeah, Mara. And that's what it seems like. They don't have it. Well, I would think that they'd have it recorded, Vix. I think that they'd have, like, if they did an interview of some measures with her, that they would have it recorded. Do you not think so? No, we don't know that she was interrogated. That's the word choice that Anne used. That's not the word choice Bill used. And so, and I've said it so many times before, it was ATS News who made such a great point on one of her lives where she explained, usually in this point in cases, you would have the defense attorney all over news media stations, news outlets, and they would be advocating for their client. They would be whether they're pushing their alibi or just speaking on behalf of them and controlling that narrative, getting that narrative out there. We can't have that in this case because of the very heavy gag order. And so what Anne is doing is she's controlling the narrative through these motions and through the time where she is on camera. So even her choice of words of Miss Vargas was interrogated. She knows we, the public, are going to see that. We are going to get hung up on that. She knows what she's doing. So she's still able to control the narrative of the public through her choice of words. She knew what she was doing when she used the word interrogated. Now, that doesn't mean that she was interrogated. Doesn't 100% mean she wasn't, but it doesn't 100% mean she was. It just means that's the way that defense is going to depict it because it works in their benefit to depict it that way. Yeah, and defense is, trust me, they are paying attention. They're paying attention to everything. They know what's going on in YouTube. They know what, like, social media. They know. Yes, Nika. Yes, 100%. I think she wants Bryan as a client. I think she does. I think there were a couple of opportunities she had earlier on when it came to the conflict of interests with her office representing members of the families, victims' families. And I feel like if she really wanted an out, she could have taken an out at a previous point. But I think Anne wants to represent Bryan. I think that this is really good for her case. I think it's challenging for her in her career. And I think she wants to represent him. Yeah. It is a kerfuffle. Then how else do you think they found the pick of Bryan's belt buckle, aka his spy? They know. How else do you think? What do you mean, Dara? I like that word too, kerfuffle. Santa is sweet, but this much attention is out of his norm. He just wanted one last good job before retiring, and instead he has YouTube all over his shit. Yes. Actually, it's good that defense is creating doubt so that they can have a fair jury, but once all evidence comes out, jury will already be chosen. Yeah. Ooh, titillating. That's a good one too. Titillating. Defense is paying attention to the naysayers also, so they will know where to plant reasonable doubt. Yeah, well, and they want to have an idea of where people are at, where the mass is going. They want to know. Oh yeah, they're definitely watching social media, Dara. Yeah. Mm-hmm. Kerfuffleophagus. Yeah, we're not gonna see. And you know what's crazy, and like what, because like Alex Erickson has been covering. She got some of the Letitia Stout case files. And what's crazy is, okay, that case has already been to trial, right? And even after trial, going through all of the case documents, there's a lot of things that never even made trial that majority of us have not even heard. And so even after trial, there's going to be so much that we don't know about, that we never will hear about. It's crazy how it works out. If the FBI used a database off limits to that, would you call it an illegal search? If it, I don't know if it's technically illegal versus it went against the sites. They were not supposed to do it. I would. So here's the thing. I think that it poses an issue. I think that it doesn't make it okay. And it's an issue that's going to have to be addressed. But if he's still guilty, he's still guilty. So where does that leave us, right? Let's say that, okay, they didn't do the right thing with how they got to him, but he still is guilty. So where does that leave you, type of deal, right? I don't know what the right answer is. Well, Amy Terry, it depends on, that's the whole thing, is they don't know which databases were used. The other databases are not allowed to have police use it, period. And then the ones that are used, you have to be opted in and opted out. But all of these people are testifying that they know police who have used the databases when they're not supposed to use the databases. Well, yeah, and they say to even have to opt out is really, really tricky and hard. Like, you're automatically opted in, and the process of having to opt out is really tricky. Well, Angel, and that's what they want to be shown. So it's Mimi, they have different ones. You know, 2 of them have no law enforcement at all is allowed to access unless there's a specific court order. Others have an opt-in, opt-out feature. It all depends. All they do know is that DNA submitted to one can't be transferred over to another database. So that is the whole point of show us what you did to prove to us you did not cut a corner. Well, their argument is, Jules, is that they're not using that family tree. It's not being used in the trial, period. They're not using it to convict Bryan. They're not using it as evidence in trial. So if the state themselves, if the prosecution is not using it as evidence against Bryan, why would they hand it over to the defense? It doesn't belong to the defense. We're not even using it. It's a tip. It's a lead. It's an investigative lead. You cannot use this to arrest someone. You cannot use it to convict someone. It's simply a lead. And so if we're not using it in trial, you're not entitled to it. Only if we are using it against you in trial are you entitled to this information. You're not. It's a lead. It's a tip. It wasn't used for the arrest. It's a lead. It's not allowed to be used for an arrest, and it wasn't used for the arrest, Vix. You have to get a direct test, like a direct DNA, and they did with his dad. What was what, Jules? We don't know if they got to Bryan from it. They might have got to Bryan from it. I don't know. We don't know if the IGG or the WSU campus security tip came first. Don't know. But the IGG very well may have came first. But the point is that it cannot, that was not allowed. No, they're not allowed to use it for his arrest. They did not use it for his arrest. Where do you see they used it in his arrest, Vix? Where do you see it in his arrest warrant? Yeah, they used his dad's. The dad's. They didn't use the investigative tree they built. The lead they built. That's separate. Yeah, which part, Vix? Which part in the PCA? We don't know that, though. We don't know if they connected him through the tree to his dad. Exactly, and we read that multiple times. We read it tonight. It cannot be used to make an arrest. But you're making that assumption that it led to his dad. We don't know that the tree led to his dad. We don't know where the tree led at all because we don't know anything about the tree. No, it doesn't say that either. Thank you, Harlot. It's two separate things. Now, that doesn't mean that it's not possible that it did lead to his dad. It could be, but it does not say that. They took them building that family tree. They had the DNA. They started to work on a family tree. They built that tree outwards in. We don't know if it started with 3 cousins, 3, second cousins. So we have no idea. And somehow it gave the tip to Bryan. Then they got eyes on Bryan. Then the closest they got to Bryan's DNA was the dad's trash. They did a direct match to the dad's and confirmed that it could not be excluded as the biological father. That is not the same as the IGG led to being Bryan's dad. That is not what it says. That is not what's stated in the PCA. I believe that they probably did too, Marianne. But if we're going by what we know, we have to be very clear with what we know versus what we believe. So we have no idea as far as the familial tree that was built, who that led to. Saying it was led to the dad is an assumption. We do not know that. Oh, really, Harlot? Well, no, they tested the trash off of the DNA from the sheath. cell phone pings are actual facts. Places that the vehicle is being spotted are actual facts. DNA recovered on the sheath, actual facts. Now, the narrative surrounding, like whether you want to create the narrative of what he was doing, that isn't an actual fact, right? You could create he was sitting there stalking them out, doing that, like that's a narrative. About what, Jules? Yeah, everything is circumstantial evidence. If you guys remember, we did a live like the other week. Blood, it could be circumstantial evidence. The only thing that really is not circumstantial evidence is catching the actual crime itself on camera or like an eyewitness to the crime itself. Everything else is pretty much circumstantial evidence. It's just a how solid of circumstantial versus how light of circumstantial it is. I don't know. You're going to have to be more specific, Jules, if you want me to like clarify something. That's very possible. Donna, they start and they build out in with the genetic genealogy tree, the familial tree. It could be a long, like far back ancestor, and then they build out, and then they start building in from like a cousin, to a distant uncle, and they try to get as close as they possibly can to the actual DNA. It's collectively, when you put it all together, that it paints a bigger picture. Yeah, so Angel D, from what I'm gathering, the defense is not arguing that the DNA is a direct match to Bryan's. They cannot argue that. So what they're trying to argue is show us the process that led you in Bryan's direction. We want to see the family tree that you built back before you had Bryan as a suspect and you just had his DNA and you were building a profile around his DNA. Show us all of that work that eventually led you in Bryan's direction. We want to see that you did not cut any corners or take any backdoor steps the way that Vargas and these other people have testified that former law enforcement officers have done before. So it's not so much that whether or not the DNA is in fact Bryan's versus show us you did this properly, and more so show us that the proper steps were taken for all DNA that was acquired at this crime scene, not just my clients. I want to see that this case wasn't built around my client, Mr. Kohberger, versus you took all of these steps vetting out all of the unknown DNA that was found near this crime scene. And I also think that if Anne can uncover that there was a misstep at process 1, that first stage 1, that there was a corner cut, then you have to question that comes everything after step 1, right? So if Anne is able to prove, because she knows shit, that DNA is Bryan's. So let me uncover that you cut corners getting there. Because if I could prove that you cut corners getting there, then everything that came after you got to Bryan has to be thrown out. I have to question the credibility of it because you cut those corners to get there. How can we trust process step 2, 3, 4, 5 when step 1 was shady? You see what I'm saying? Well, whether it will or will not be is another question, Mara, but that's what I feel like, that's what Anne's intentions are. And that's because I think that she doesn't have much she can fight. I feel like she is stuck with it is Bryan's DNA. And so possibly, and it depends on how bold she is, possibly if she can prove that they even cut corners, will she take the jump with saying as far as it being possibly planted? I don't know. It depends on how solid the rest of the evidence is. Because if she can expose a corrupt cop, which again, cutting any type of corners, that's how I would focus on, right? You're corrupt. You're cutting corners. You are doing something you're not supposed to do. Well, now that I proved that you are not credible, that I cannot trust you, how am I supposed to trust DNA that you supposedly found on this sheath? How do I know that you did not now plant this DNA? You know what I mean? So if she could expose the corruption, she can now question everything that comes after it. But I think yeah, I agree. I agree. Yeah, we don't know. And I remember hearing much earlier on, the DNA doesn't have to be planted. I'm saying though that it could open the door for these type of arguments. It depends on like how far you want to go down though. That's like I said, that's if she really wanted to get bold, she could do that. But what's it called? It could be, I remember hearing earlier on, it was something, and this was way earlier on, something about an aunt that had submitted DNA to one of these ancestry databases. But that was just hearsay, so who knows if that's the truth. I know, Mar. Me neither. I don't like it either. Like I said, I think he's the right guy. I think he is guilty. Well, I don't think it's as that simple, Andy. It has to have direct contact, number one. But number two, that's why it's collectively. It's not just the fact that his DNA is on the sheath that was beneath one of the victims that are murdered. It is not just that his phone is doing these unusual, pinging in the area and doing these unusual disconnecting from the network at the same time that the murders are occurring. It is not just that his vehicle is caught on camera in the neighborhood at the time that the murders are occurred. When you look at these collectively and put them all together, They paint a bigger picture. You cannot look at them singular individually. You need to look at them collectively. Dun, dun, dun. Okay. All right. You're one of those, Andy. Okay. So again, phone pings, blurry car are totally nonsense. That's not true. Number one. Number two, blurry car. According to I didn't know that you had access to all of the footage that they have. If you're referring to the Linda Lane, we're not even supposed to have that. We don't even know that's legit. You don't have what they have. So please do not say that's nonsense, because we are not privy to the evidence that they have. Okay. To say it doesn't add anything at all, that's silly. We need to wait till trial. Nobody can say what they do or do not have. We do not know. We have the PCA to refer to and the motions filed. That's it. That's it. But I get very frustrated when people say that, because it's silly for you to say that. That's the only thing that's silly. You do not know what they have. No, I don't know what they have. I don't, but I'm not the one sitting here saying that they do or don't, right? You are. You're the one saying that. Thanks, OCD Shaggy. I will not renege the super chat. All in good fun. Thank you. So kind of you. Very much appreciated. He can have his opinion, but it's silly to again make the assumption of what they do or don't have. We don't know. We have to wait till trial. But you don't know what they have so far. That's exactly my point. It's only fair to go off what they have so far and judge. But you're saying what they have so far is what we've been able to see. That's not what they have so far. That's what we've seen. See, I can't answer that, Twizzle Stick, and I don't know what's up with the footage. I don't know why they got the year wrong. I don't know why they didn't correct it. That's a great question, and it's something that I'm going to be wondering all the way till trial. And I'm going to be wondering whether or not they caught, because I struggle with them not having at least partial of a license plate. I struggle with that. But if they had even partial of a license plate, it should have gone a lot quicker than it did. And it didn't. I can't wait to hear the 911 call either. You think he changed plates, Avenue Mall? Hey, MK. Look at your new picture, Claus. Exactly, Michelle. If all they have is what's said in the PCA, what in the world? Well, they shouldn't, Twizzle Stick, right? Because the PCA is not supposed to be, the PCA is only supposed to be about 10% of what they have. So it's not supposed to be all that they have. I don't think they corrected the year because they initially thought that it was 2011 to 2013. By the time they got Bryan's name, no need to correct it because they had their guy. That's what I heard. But I don't know. You looking sexy, Claus. Yeah, Angel, me too. I would struggle with it not seeing his plate. That is weird to me. Unless he took the plate off, but I don't know. It's clear to most people he's totally innocent. It's no James Bond. I don't think nobody should be sitting here saying, oh, he is absolutely 100% innocent, and nobody, what's wrong, Mimi? And nobody should be sitting here saying he's 100% guilty, because there's no possible way before trial we could say one way or the other. How can we say when we have not seen any of the evidence yet? That's not fair. So of course, you can lean in a direction. It's totally fair to lean in a certain direction. I am absolutely leaning in the direction that Bryan is guilty, but I cannot say for certain one way or the other because I have to wait for trial. Well, yeah, he's innocent until proven guilty. Yes, as far as that. But I'm saying, people are 100%, nope, he didn't do it. You don't know that. In the same way I can't say, nope, he 100% did. We shouldn't. Okay, but people have done it before, right? People have done it before. If that's the only reason you think Bryan is innocent is because, whoop, wow, that's a cocky move, that's not enough. Well, that's a great question. If that's legitimately factual, that would tell me that Ethan wasn't originally there when the door was shut and then he had later moved, which is horrific to think about. Michelle. Yes, he did. That's exactly what I was thinking about, Amy. Other people have done it before. Okay, so it wasn't without noise, it wasn't without DNA, and it wasn't clean. There was noise caught on the neighboring camera 50 feet away. Dylan heard noise. His DNA was left on the sheath, and there was blood all over. The coroner said there was blood everywhere. Okay? It was not clean. Now, if you're referring to why isn't there blood in his I agree with that. That's strange to me, and I won't disagree with that. But it wasn't quiet, no DNA. That's not true either. She heard cries, whimpers, there's someone here, and the neighboring camera picked up thuds, cries, and whimpers. Bryan's DNA was at the scene, actually. Andy, Bryan's DNA is on the sheath at the scene. No, it's not all according to Dylan. It's on the neighboring camera, picked up in the audio at 4:20. I know, I hate my butts too. I don't like my butts either. But I do believe that it was obviously bloody. I'd struggle to believe it wasn't bloody. Oh, it doesn't. See, but you can't do that, Andy. It doesn't count to you. So you're saying that there's no DNA, and then I'm like, no, there is DNA. And you're saying, oh, no, but this DNA doesn't count. No, it does count. It's his DNA. It's his DNA. It does count. You can't turn around and say there's no DNA anywhere. Yes, there is. There was enough to identify Bryan on the sheath at the crime scene. You don't get to just say that doesn't count because you don't want it to count. That doesn't work like that. Yeah, as far as the second floor twizzle stick, yeah. Claws. Well, within the home, Matt Lowe, it didn't say. We don't know where within the home it is. It could be completely not near the deceased, or it could be closer to the deceased. We don't know. You don't know if it... Okay. I'm not doing this. That's possible, Angel. I'm curious if at some point they have changed their testimony at all. Twizzle Sick is going by I know. I know. But Twizzle Sick is going by what Chrissy allegedly told Daniel from the Drunk Turkey show. Yes, we can see you, Marion. As far as Hunter being summoned because they could not get the second floor, like Xana's door open, and then he had to push the door open because it was being blocked by Ethan's body. That's what he's referring to. So he's saying for Ethan's body to be there because Bryan could not have shut the door behind him and Ethan's body being up against the door, it would mean that Bryan shut the door and Ethan eventually crawled and then would be blocking the door. Or else, how else would he be blocking the door? Okay, we're not invicting a sandwich here, Andy. I understand that there's a lot of questions. Yeah, Hunter had to push in. It was not locked. It was blocked. Allegedly by Ethan's body up against it. So the question arises, how did Ethan's body get up against it? Because obviously, if he was killed in that position, it could not have been there with the door shut up against the door, unless he originally started maybe like a couple feet away and then inched to the door and laid there. But I understand that people have issues. I have issues also. That doesn't make sense, but people making the jump that there's absolutely no way that Bryan could have done this, I don't think that's fair either. You do not know all of the evidence yet to be able to say that. Nobody's saying. There always has to be the one. The same way that we cannot say with 100% certainty that Bryan did it without a doubt, you cannot say with 100% certainty that Bryan did not do it without a doubt. Nobody can say with 100% certainty one way or the other. Why can't we all just agree with that? Like, I feel like that should be the one thing we could all agree on, is we can't say one way or the other until trial comes and we see the evidence. Must have 87. Oh, man. It's not physically impossible. And if you think it's physically impossible, then you need to go educate yourself. It could be unlikely. It's not impossible. Not impossible, though. And if you're gonna say that, please have the evidence to back it up. If you're gonna say that it's physically impossible, please have the research to back it up. Again, everybody in here, I highly doubt that you'll find one person in here who will not disagree that it isn't tight and damn, like, like this is tight and it's, like we all struggle with how quick it was done, but don't come in here saying it's impossible. It ain't fucking impossible. Nika. Yes. Oh my God. Oh, that just made me like laugh. That's exactly how I got it ended up too. I think Sarah Boone. So Sarah Boone has Michelle. Sarah Boone has 2 more letters. I think she has court tomorrow. She has a hearing tomorrow. Okay, Andy. You're the only one willing to be honest here, yet you're not even here with your real name. Sure. If you say so. If you say so, Andy. Oh. But what's it called? So I think I'll be live tomorrow in the afternoon to cover that. CD Shaggy. You ain't Andy Dunn. Give you a fucking break. Come on. Who are you kidding? I know, Jen P. I just want to know if the judge is gonna remove her attorney. Spigot. Well, they don't say it's 16 minutes. Bueno Lover, they literally took half the time and they say it's only 8 minutes. I don't know why. Boone the Loon. You don't know who Sarah Boone is, Mara? Okay, Sarah Boone is the woman who recorded herself she recorded as she zipped her boyfriend up in the suitcase and he slowly suffocated and died. And she recorded herself as she mocked him and taunted him and made fun of him. And he was begging her to let him out. And the next day she called the police and was like, oh my God, we were playing hide and seek. I had no idea what happened. And now she's on awaiting trial. That's going to be happening in a few weeks for murder. But she has gone through 6 attorneys so far. And she writes the judge some pretty entertaining letters. And so her most recent attorney is asking to be let go. I don't know if he was let go yet, Amy, or tomorrow is the hearing where the judge will like either approve. I don't think the judge is going to approve it because the trial is supposed to start in a few weeks. Bankowitz has been on her case for over a year. Boone is entitled to a lawyer. There is no way he's going to approve Bankowitz getting removed and then throw a new attorney on and expect this attorney to be prepared in weeks for trial. So I think he's not going to approve Bankowitz leaving. Right, Amy. I can't see that. Well, if you didn't think Boone was guilty, that one is literally recorded. How do you not? How could you say I don't think Boone is guilty? But she recorded it. Like, that's a crazy one. But Boone has accused the judge of like basically selling the video for profit. Oh, Marion, yeah, it's crazy. She's like, I wonder how much you've made from this from this video circulating on the internet. What's your cut? Yeah, exactly, Nika. What's your cut? Oh man. I haven't seen Willie around since his lady friend's boob popped and he had to call 911. What? What? Wait. What? What did I just read? Wait. What? I haven't seen Willie around since his lady friend's boob popped and he had to call 911. What? Wait, what the fuck happened? Yes, Willie hooked up with some chick at a hotel she paid for in her. Oh my god. Oh my god. Oh my god. I'm trying to hold it in, but I can't. Oh. Renee. Oh my god. Oh my god. So her boob just It was the second time. Oh my god. Oh my god. So one boob just deflated. Shit. I gotta stop imagining it. So I stopped laughing. Oh no, that's so sad. And I hope she's okay, don't get me wrong. But I just did not expect that. Oh man, that's why you don't order them off of Wish. Oh god. Oh man. I didn't know that could happen. Oh god, but twice? Oh god. Sorry guys. Just did not expect that. Laughing because they said the boob reneged. Oh god, okay, my stomach really hurts. Oh man. Timu boob. Oh god. Gotta get it together. Oh god. Okay. I'm gonna pee. Seriously, stop. Oh, God. Jesus. I'm sorry, guys. Oh, fuck. Okay, I'm done. I think I'm done for today. I can't. I can't. I can't. Okay. Oh, I gotta get off because I won't stop. I'm starting to sweat. Oh man, that was the funniest shit. I'm just imagining him. Oh, on the boob. On the boob. Oh shit. Oh my goodness. Oh, I just did not expect any of that. Shit. I was so caught off guard when OCD is like, I haven't seen Willie. It's this girl's tit fucking deflated. And I was like, what? Her fucking boob went fabar. I don't know. Did it fall out? Did it like just deflate in? I don't know. I don't know. I don't know. It didn't happen here, Bikram. Oh, so you're telling me Willie sat in this hotel and came on a panel? He's all like, what do I do? Oh my god. Oh, and I feel bad for the guy. Oh man. I need water. Shit. Is she okay? It happened twice? Fuck. I heard a story years ago where this girl got speared by a swordfish and her implant saved her life. Jesus Christ. I saw this video once of this woman's butt implant that, like, I guess it wasn't secured and she had the ability to like flip it, like, and it was the weirdest like thing. Like, she would just flip it while it was just in her cheek. Oh my god. You think? Ah, but that could be dangerous. Like, all laughs aside, 15 minutes later. That could be dangerous. Oh. Jeez. Yeah, I'm sure you could still find the video, Michelle. Just the girl who flips her butt implant around. It's crazy. Oh no. That's scary, Harley. Yeah. It was leaking externally. No, yeah. Oh, yeah. It wasn't. I was going to say, there's no hole. Yeah. Yeah, let's just go all natural. I don't even know. I got some fix a flat. Stop it. Oh man. It must have been oh my god. Matt's correct though, because they have changed the boob implant formula and they don't bust anymore. So they must have been older. Oh my god. Oh man. It's too much. This is too much. All right. I'm cutting it off. I will be on tomorrow afternoon at some point to cover Sarah Boone and the letters and the hearing. Other than that, I wish her breasts all the best. All the breasts. Oh my god, I got a tinkle. I really gotta go pee. And thank you all so much for being here. And I hope you all have a wonderful night. And oh my god. It's not savable. It's not savable. But yep, I will see you all tomorrow. So have a wonderful night. Thank you so much. And I'll talk to you all soon.